Good morning, everybody. My name is Penny Simpson, and I lead the Natural Capital legal team here at Freeths, which is a law firm, just in case you weren't sure. Welcome to our first of 4 Natural Capital legal webinars. This webinar is called Is Your Land Suitable for Being Used as a Habitat Bank? And there are 3 more webinars which we're putting on in October, which you can see on the screen now, which relate to other issues to do with setting up or running habitat banks. So please feel free to join us on those other ones. And I think Tom has just put into the chat the link to allow you to register for those if you haven't already done so. Okay, so thanks a lot for joining. We've got a large team of lawyers at Freeths, which make up our Natural Capital legal team. In fact, we have 27 senior lawyers as part of the team, and that covers 7 different disciplines of law. So we have environmental lawyers, real estate lawyers, and planning lawyers, and both of those 2 sets of lawyers are represented here today. I'll come on to introducing them in a second. And then we also have within the team corporate lawyers, tax, commercial and property litigation. So we can deliver any kind of advice you need on natural capital projects. So please feel free to get in touch if you have any work that you need help with. So then I also want to introduce our 2 speakers today. So we have Gareth Forty, who is a real estate lawyer from our Bristol office. And he's going to be talking about some of the real estate things to think about when you're setting up a habitat bank. And then Chris May, who's a partner in our Leicester office, he's a planning lawyer, and he'll be talking about some of the planning and other related constraints that may come up. So I think Chris is going to go first. So I'm going to hand over to Chris. Thanks, Chris.
Thanks, Benny. Good morning, all. So I'm talking about what you need to think about before considering setting up a habitat bank at your land. It's all concerned about nature markets. So we've got the biodiversity net gain. Now, that's now mandatory for most developments. There's an opportunity there because it's now mandatory. We've got nutrient neutrality, water neutrality, and also the voluntary market. So this is where businesses, corporations want to show their commitment to corporate social responsibility, or just want to improve the public's perception of them. So they go out of their way to acquire nature market units. And the key point is that all of these aspects provide an opportunity for landowners to create units to sell to developers or other parties, and therefore there's an opportunity to create value and money out of them. This is just a overview of a flow chart. It's specifically aimed at BNG. It's just from the government website. It just gives a good flow chart effectively of what the steps are in terms of habitat banking and creation. In terms of how you secure the delivery of enhancements to create habitat banks, there are 2 distinct mechanisms. The first is the Section 106 agreement. That's under the Town and Country Planning Act, planning obligation, and that agreement is made between the landowner and other people with interest in the site and the local planning authority. And then the second mechanism is a conservation covenant, and this, rather than being an agreement with a local planning authority, is an agreement with a responsible body. Now, responsible bodies are designated by the Secretary of State via DEFRA to ensure ensure compliance with habitat creation agreements. Currently there's 33, and they pretty much cover the whole of England. More are coming online, but it does provide an alternative to the local planning authority route with Section 106 agreement. Now, this is just a good visual aid in terms of what's involved in the creation of habitat banks and the steps that would need to be taken through. Obviously, the overall opportunity is to sell units to developers. So there's got to be contracts between the developer and the landowner. This step involving Natural England is only really applicable to BNG units, but there's always going to be this step. Hopefully you can see my cursor, which is the Section 106 agreement or conservation covenant for the habitat enhancement and maintenance. So what to think about? So you've got a bit of land. You're thinking, well, is there an opportunity here for me to create units which I can sell? Which is the best route to go down? So in terms of the actual obligations, whether you use a Section 106 agreement or a conservation covenant, the actual clauses, the drafting is pretty similar. Really, it boils down to a question of practicalities. Most of the time, my clients, they explore the opportunities with the local authority. So what you want to do is have a look at whether the local authority has experience, whether they're currently doing any other habitat banks, the costs involved. If the local authority doesn't currently have any agreements or has no experience of it, then it's often worth exploring a responsible body. In practice, what I'm finding is that some local authorities are really up to speed, and they will work positively with your client or with you as a lawyer acting for the client. And the process can be relatively straightforward. Sometimes local authorities don't have a clue about it, to put it bluntly, which can lead to delays. And sometimes you're just stonewalled, or clients are just stonewalled because the local authorities don't have the resources. In reality, there's not much in it for them. Effectively, they'll get all the costs covered, of course, but ultimately, it's not part of their statutory duty to do this. So there can be some pushback, or I say some stonewalling, in which case you need to explore responsible bodies. Often responsible bodies I'm finding are more expensive to deal with than local authorities, both in terms of the costs of getting a conservation covenant agreed, but also in terms of monitoring and management fees going forward. But the big benefit is they know what they're doing, and they've got a model set up. So I find it a lot more efficient, and they have their steps to go through. And if you work with them on those steps, it can be relatively painless. The next thing to consider early on is obviously you need to get an ecologist to prepare the habitat management and monitoring plan. It's really important to understand what the current status of the site is in terms of its baseline value, because ultimately you're going to have to ensure that you're creating significant or sufficient gain to make it worth your while. And really, you need to get some ecology advice very early in the process. A lot of the points in terms of early considerations are to look at it from a perspective of what are the obstacles in terms of preventing the creation or management of the habitat bank over the 30-year period, which is for BNG, or the 80-year period for nutrient neutrality. And there's plenty of those or potential obstacles, some of them planning related and some of them property related, which of course Gareth will come on to later. The first one I'm going to look at is whether there are existing legal requirements which you already require the creation of habitats on the land. And these can be, for example, we're working with a solar farm which already has a planning permission and which has a landscape management creation condition which only requires net gain. So it was pre-mandatory BNG, it just required a 0.01% net gain. The question we've been asked is, does that mean that we're unable to take advantage of using the potential for the site, which is a huge site, to create a habitat bank, so effectively create biodiversity units which could be sold to other developers? Now, the conclusion we've reached is that, well, actually, the requirements of the planning permission is only a net gain. Therefore, there is an opportunity to go beyond that net gain and create additional units which could then be sold. And we're going through that process now. Other aspects of additionality, if your site is already subject to habitat creation for district licensing, for example, then there are opportunities to also create BNG units, but it needs to be explored, and you can't rely on anything you've done to provide the other habitats as them being able to be sold for BNG purposes. Other aspects are green infrastructure requirements. The general rule is that they're okay to be not double counted, but you can take value out of those and creating those and then selling the units. So there's lots of different rules for different aspects, but it's something that you really need to think about early doors to make sure that all the money you're spending on ecologists or your money you're spending on lawyers, you're not ruled out automatically because you've already agreed to do something else. I think that's the headline point there. Next, protected species. Obviously, any work which you do in terms of habitat creation and which may interfere or harm or disturb protected species, you need to be really careful about that. So again, your ecologist will be able to advise on that. Other designations, one we've experienced recently is whether it's in an airfield safeguarding area. And in that regard, it's a question of whether the habitat creation would result in the risk of additional bird strike. So again, it's something that needs to be explored early doors. Contamination and environmental risks. This comes back to the point as to whether or not the actual ability to achieve the habitat gain or the biodiversity gain of the habitat is realistic, having regard to those environmental and contamination risks. The practicality of creating habitat. These are all thinking about water supply. Can you actually be able to create the habitats on the site with the physical infrastructure in place, and the extent of works required? Pretty much every habitat bank I've advised on hasn't required planning permission, but there are circumstances where the extent of the works, for example, engineering works, they may well require planning permission. So that's something that needs to be factored in to your consideration of whether your land is suitable. The next one is the business case and financial information. So both local authorities and RBs are requiring effectively proof that you've got the ability to create the habitats from a financial perspective and then to manage and maintain them for the 30-year period. They're often seeking protection in the forms of bonds, cash deposits, and that's community interest corporation. So that's ways of setting it up to ensure that you can demonstrate that you've actually feasibly can deliver the works and the ongoing management and maintenance. Other things to look at, the local land charges and other statutory processes. So clearly, if your land is subject to a pending CPO, then I don't think the LPA or the RB are going to be really interested in it. For future ones, we have been dealing with this in the drafting. So we use a force majeure clause to say that any CPO which may come forward and affect the land, effectively, you can take advantage of force majeure and the liability ceases. But as I say, if there is any risk or any known risk of a CPO at the point in time of seeking to agree the Conservation Covenant or the Section 106, then I think it's something which the RB and the LPA just won't be very happy with. You also need to think about the structure, and by this I mean who's going to be responsible for compliance and how it all works. So if you're a landowner and you're proposing to do the works yourself, then that's pretty straightforward. If there is a tenant being brought in to create and manage the site, then that's an added level of complexity which would need to be considered. Other people have been looking at special purpose vehicles just for the delivery of the gains. Lots to consider. Structure, there's tax implications, there's property implications, all which you need to think about before deciding on the best route for you. And it's also important for future registration requirements, because what I'm finding, this is only related to BNG, is that clients are thinking that, yeah, they've secured the land, they've secured a conservation covenant, and they've got all the 106, and then they can effectively bring in the money. But the process then needs to be, you need to register it with Natural England. Now, if the habitat operator is a leaseholder, then Natural England will require that lease to be registered, which means you're going to have to wait for HM Land Registry to go through the process of registration. Before you are able to register the site on Natural England's register, you'll also need to get the land charge certificate confirming that the Conservation Covenant or the 106 has been registered as a land charge. Again, that can lead to delay, and it's just something to keep an eye on, that you can't just expect the money to start coming in once you've agreed the agreements. There is an ongoing process and other steps that need to be taken into account and need to be factored into your decision as to whether or not you want to bring forward your site. So that was a very quick overview, and now I'm going to pass you on to Gareth.
Morning all. This is a quick run through on the real estate elements to the Habitat Bank creation scheme. So first point is the responsible body or local authority, whichever route you go down, will be assessing the suitability of the site from a legal risk perspective, deliverability perspective. So first of all, who is the actual party delivering the scheme? Is it a company? Is it a charity? Is it a partnership? Is it a trust? They'll want to understand the nature of that company, memorandum of articles, charitable trust purposes, etc. And additional risk if the company is offshore. And how do you manage that risk? And then leading on to some of the actual title elements. First of all, obviously you want to make sure the person owns the land. If they don't own the land, are they acquiring it? And if they are acquiring it, they want to see how they're acquiring it and how that's going to be structured. And then the next point, is land registered or unregistered? And at the moment, Natural England won't accept unregistered land for BNG purposes. Moving on to some particular risks with the title itself. Easements. Are there any easements which the property is subject to, which may affect the ability to deliver a scheme? Have people got unfettered access to the site for vehicles, etc., with designated routes? And also another point is, if the site is accessed by a right of way, is the right of way sufficient? Secondly, are there any restricted covenants affecting the site? It may prevent you from actually delivering a scheme. It may be defined or used for a specific purpose, which the habitat scheme may breach. Then going on to leasehold title. If you've got a lease of the land, a long leasehold, you may find there's restrictions on your ability to enter into planning agreements if necessary, and also to ask the landlord to enter into necessary conservation covenants or planning agreements. Another aspect to think about are mines and minerals. If the groundworks are such that they will affect the subsoil, you're creating wetlands, ponds, lakes. If you don't own the mines and minerals, you may be trespassing on those mines and minerals. Another point, it's less of an issue because you're not making a disposal unless you're creating a leasehold interest. But there may be an overage which may affect the scheme. Increasingly, I've been dealing with overages when land is being sold, which tries to capture enhancement created by habitat schemes. And then going forward, occupational interests. Are there any interests on the land, such as farm business tenancies or leasehold agreements, which may need to be secured by vacant possession to terminate them to make sure the scheme can go ahead? And lastly, is the property charged? If the property is charged, the bank will certainly have to be a party to the conservation covenant or responsible body conservation covenant, or section 106. And if the property is charged, also you may need permission to undertake any planning permission. And then finally, the searches, the local authority or responsible body, depending on the nature of the works, may wish you to undertake some searches, utility searches. If you're undertaking wetland work, planting deep-rooted trees, that may affect utilities. So they want to make sure that your scheme doesn't impact upon those. And Chris has touched upon this, common land, town and village green. If the site is registered as common land, that may affect the ability to create the habitat bank as well. And you're likely to encounter a long set of inquiries raised by either the responsible body or the local authority, touching upon, for example, any informal agreements which may crystallise legal rights. There may be some manorial rights, such as sporting rights, the right to hold markets or fairs, grazing rights, mineral rights. These are what's called rights which may affect the site even if they're not registered. So you need to make sure that those rights do not exist. Chris has also mentioned about conservation designations. Has a SSSI been registered on the site? Finally, are there any agri-environment or other land management schemes affecting the site? Will they impact upon the ability to deliver the scheme? And of course, you can't double count. Just finally, some specific examples we've encountered in practice where you've got local authority land. If it's designated as public open space, is the creation of the habitat bank, will that affect the nature of the public open space? Can it still be used for recreational purposes as designated? If not, the local authority might need to appropriate land for alternative use, and that will require advertising pursuant to the Local Government Act. And finally, charity land. You need to understand the nature of the charitable trust. What's its charitable purposes? The primary duty of the charity trustees will be to ensure that the assets are used for the specific charitable purpose. If it's not clear, the Habitat Bank may impact upon the charitable trust's purposes. That's a very, very quick run through of some real estate issues I've encountered and some points you'll need to make sure you're fully forearmed with before you approach the local authority or responsible body.
Thanks, Gareth. Well, I'll go through the questions now. We've had a few. Hopefully, we'll get through them within the next 9 minutes. But if there's anything that anyone wants to ask us, drop us an email, and we'll come back to you. If it's a general one, we're happy to do it for free, obviously within reason. But I'll start with the questions that have been asked in the chat and in the Q&A tab. First of all, this is from Martin. If the delivery is by a tenant, they will likely have a 5-year lease, for example. Whilst we'll know we'll be committing to 30 years for BNG as freeholder, but there might be a limited number of different tenants. Is this catered for or feasible? Well, I think I'll go first of this from a planning perspective. I think I would be concerned that the RB or the LPA won't be happy with the delivery body, which seems to be the tenant, will only having a 5-year lease. I think there are ways to protect their interest by ensuring that it's enforceable against a freeholder, but presumably for anything, if it's a continuation of tenants after tenants only on a 5-year lease, then they wouldn't necessarily have a legal interest registered in the land, and there may be some issues about whether they can even go after the tenant. They should do, because they be able to in terms of successors in title, but it would be a bit messy. I think it's in theory feasible, but whether it would be acceptable to a tenant or to an RB or a local planning authority is a different question.
I think certainly in that case, you'd have to make sure the freeholder is subject to the conservation covenant, because it won't have sufficient interest tenant.
Yeah, it's completely. And then if it is BNG, then obviously there is a complication of the Natural England registration process, where there is tenants and landlords. They tend to be pretty pragmatic, so they look for the clause which ensures that all the obligations are enforceable against the freeholder or the landlord in the case of any of the lease terminating or the tenant becoming insolvent. So they are pretty practical from my experience. But again, this would be an unusual situation, and it may raise more questions with Natural England as well as the RB and the or the LPA. Okay, next question, Paul, and I'm only saying first names because on my screen I can't read the surnames. But that's Paul. Can habitat banks be layered with other provisions, e.g. SANG, nutrient neutrality or carbon credits?
I can answer that if you want, Chris.
Yeah, go for it, Penny.
So this is a strange, this is a good question, and the government's answer is quite strange in the sense that there isn't a kind of general explanation as to their position on this stacking idea. It's more that they just make specific announcements at specific times about what they do allow. So we know that they do allow nutrient neutrality and BNG to be stacked. So that's good. As for SANG and BNG, if that's what you mean, I think it is, Paul. I don't know, is the honest answer. I suspect the answer is that you would be allowed to use the same site, but you'd have to do more over and above. So your SANG might deliver a certain type of habitat for dog walkers, but then you might have to do another 10% more to get to the BNG. So your SANG would be effectively a no net loss, but you'd have to do more to get to your 10% BNG. So I think the SANG might not be straightforward. Carbon credits, I don't know either. You have to go to the gov.uk advice and specifically look for the scenario you're dealing with. What I'm trying to say is there is no kind of overall policy that allows lawyers or other people to understand what the actual fundamental rules are about this. I don't think the government has published any such rules. So it seems to be a kind of piecemeal approach, which is frustrating.
Questions in the Q&A then.
Yeah, shall we move on to that? Do you consider, this is from Adam Richardson, and I can now see the surnames. Do you consider BNG will be a long-term planning requirement, or do you feel that this government or successive governments may scrap BNG within a period of time? My view on that is there's been a lot of work that went into it. I think in the end it was rushed out without properly thinking it through in terms of the practicality, but people are getting to grips with it now quite well. We've got the planning and infrastructure bill, but I don't necessarily think that there is an intention to scrap the basic premise of
I mean,
10% BNG.
we've got the consultation that suggests that small sites may become exempt from BNG. We don't know the answer to that yet. It's certainly my opinion that we'll have BNG for a while, but it may not be applicable to all the small sites. We don't know that, but I think if I had to bet, I'd say it's going to stick around.
Yeah. Okay, and then we've got TY. I found the guidance on additionality a bit ambiguous, confusing. Yeah. Regarding use of the same units, is further uplift on previously agreed BNG through further later agreement investment and acceptable additionality, please? So we are covering off the fact that you may be able to, you may create more units than you originally envisaged in a 106, but that requires effectively those additional units to then be subject to a further deed of variation of 106, and the 30 years runs from that point in time. So it is something that can be covered off in drafting.
But it's also the case, isn't it, Chris, that you have to reach the condition required for the initial units.
Yeah.
It's only if you reach the condition required for the initial units before the 30 years is expired that you would then be able to build on further units over and above that. And as Chris said, those additional units would then have to have their own 30-year commitment.
Yeah, exactly that. Yeah. Okay, next question. Commenting on landowners achieving Section 106 in planning and their knowledge that they are selling to another to deliver at the time of planning. So is this yeah, I think this is where a development washes its own face, but actually also creates additional units over and above its requirement. Yeah, there's no problem with that. I think if they create more than their 10% net gain, then they can, in theory, sell those additional units. They have to go through the formal process of ensuring that those additional units above that 10% gain are secured properly and then they'll have to be registered, and it will then become effectively an off-site habitat bank for another developer to buy those units from.
You'd have to be clear, wouldn't you, Chris, that with the local planning authority that is dealing with your application, that you're not offering more than 10%, because they need to understand that the excess is not for this development. Otherwise, you'd be in the example you said earlier about not being additional. Do you know what I mean? So you've got to be clear with the local authority that you're only offering 10% for this one development, and then everything above is separate. Yeah,
definitely. And if they had, I suppose, if they'd said, oh, one of the benefits of our scheme is we're going beyond the mandatory 10%, we're offering 40% biodiversity net gain, and the local authority gave that weight, then yeah, they wouldn't be able to sell those additional above the 10%. But in the scenario where they are clear and they're existing 106 or 106 in relation to their BNG sets out that it's 10%, and then there's additional ones which they propose to sell, then I don't see any issue with that. Okay. Well, I'm going to flood of those.
It's 10:30, so we probably only got room time for one more question.
Okay.
Shall we go with the anonymous attendee, maybe? Do you have some ballpark figures for costs of 106 for Concove?
Yeah, good practical question. Yeah, so they vary widely. Certainly the 106 costs do. The cheapest I've seen is probably £2,000, whereas the RB's legal costs, this is just for agreeing the agreement, RB's are probably around 15 grand starting. But some local authorities, they're charging 8-10 grand. So there's a massive range for local authorities, but for RB's, they are generally much more expensive, but they are all around
Are you
Team
talking about our costs, Chris, Freeth's cost, or are you
No, I'm
talking
talking about the council's costs.
I see. The costs we have to pay our clients, we don't need to pay the council to,
Yes,
right.
yeah.
Our cost would obviously be on top of that.
Yeah, our costs on top of that, but they would be very similar for a 106 or a
I
conservation.
see. Okay. Thank you. Yeah.
I think T White's asked, is that to execute or arrange? Is that the same question, I think? So I think the costs,
Yeah, so that would be to completion of the 106 with local authority or completion of the conservation covenant with them. That's the legal costs. On top of those, there will be costs in terms of due diligence costs, potential enforcement, endowment costs. But in terms of straightforward legal costs, in getting the agreement to a position where it can be completed, councils, i.e. Section 106 agreements with local authorities, tend to be a lot cheaper than RBs at the moment.
Okay. It looks like we've come to the end. I mean, there are some really good questions in the chat.
I know, it's a shame.
If any of you are keen to get those answers, please use the contact details on this slide to contact us. Just put your question back in if you really want to hear from us. Put the question into an email. We won't reply to every single question here because it takes time. So, but if you do really want a question answered, please do email us. But otherwise, thanks a lot for attending, and please do register for the other webinars we've got planned for October, like I said earlier. Okay, thank you very much.